courtroom right away. So we're going to try that again. Good morning, everyone. Good morning. You see, now I know everybody's awake. And you can't complain about the rain because we were asking for rain. And so you have received what you've asked for. All right, everyone. You are in the 187 District Court. It's on the 4th floor, and I'm Judge Boyd. So let me see how we're doing. What floor are we on? What's the court number? 7. What's the judge? All right. Now you're probably saying, why is she asking us these questions? We know where we are. The reason why I ask those questions is because guess what? If any of you ever need a break or we take a break, you all have to step outside. Nobody can stay inside. So with that being said, if you ever need a break, just raise your hand and let us know that you need a break. And so you will have to leave. Everybody will have to leave. And it never fails. When that happens, we always are missing a juror. And then the deputies have to find them. There are announcements made throughout the building. And we find that person trying to go to another courtroom. And they say, you know, I looked up, everybody was gone. So if you ever lost, if you just remember the 187 District Court, I don't care where you are in Texas, there's only one 187 District Court. There's only one Judge Boyd in Bexar County. So if you ask anybody those things and say, I'm looking for the 187 or I'm looking for Judge Boyd, you will be directed here. So this is the state of Texas versus Marco Antonio Moreno Vasquez. I'm going to have the parties introduce themselves to you.
Good morning. My name is Megan Galloway and I represent the state of Texas.
Good morning. My name is Lauren Espinoza and I also represent the state.
Good morning. My name is David Garcia. I represent Marco Moreno Vasquez.
All right. So, ladies and gentlemen, we also have an interpreter here. And the interpreter, if you could state your name, please. All right. And then we have an interpreter in training with her. If you could state your name. Right. And then you can see we have someone in the witness box who is not a witness. What is your name, please?
My name is Andrea Vera.
All right. So sometimes we have people here who are thinking about different occupations. So they come in like to view so they can decide if this is something they really want to do. She, I believe, is with the state. Yes. And I think she's an intern with the state. And then we have the other prosecutor here.
Good afternoon, everyone. Morning.
And that is your name, please.
Sorry, my name is Brandon Breeder. I'm with the state of Texas.
All right. So you will see people come into the courtroom. Maybe they're just here to watch. Sometimes people will come through that door. They're coming through that door because they didn't read the sign that says we're in a jury trial. Do not come through this door. Sometimes people will come through this door. Just ignore the people who are coming through this door and this door. The people coming through this door are for me specifically. Usually it's for orders to sign. It's something that's unrelated to this trial. I just want everyone to make sure that you focus on the trial. Does everyone understand? All right, so the parties have stood up and introduced themselves to you, and even the people who are just here to learn, raise your card if you recognize any of the parties who've introduced themselves to you. All right, so no one has raised their cards. To my left is the court reporter. Cindy takes down everything that everyone.
In Judge Stephanie Boyd's courtroom, 2 cases unfold that reveal the human weight behind the law. First, the state of Texas versus Maria Anuanette Neely. Facing a manslaughter charge, she enters a plea of no contest and pleads true to a repeat offender enhancement. Under a negotiated plea agreement, Judge Boyd sentences her to 8 years in prison, ordered to run concurrently with a pending federal case. But before closing the case, the judge turns to Neely with a warning that cuts through the courtroom's formality, a reminder not to waste her life behind bars. Next, the state of Texas versus Lorenda Tanguma. The state proceeds on a lesser included offense, assault causing bodily injury, a Class A misdemeanor. Tanguma pleads no contest. Judge Boyd grants 6 months of deferred adjudication instead of a full year of probation, conditional on anger management, no contact with the complainant, and random drug testing. The case is transferred to Brewster County. In the end, it's Neely's sentencing that lingers, a reality check about the cost of the choices that brought her here.
Is saying that can be difficult. The reason why it can be difficult is because guess what? Some people want to mumble. Some people speak very fast. Some people whisper. We can't do that because Cindy needs to hear. And the acoustics in this courtroom is horrible. Have you all been able to hear me in the back?
Yes.
All right, if there's any time that I'm speaking or either party is speaking and you can't hear, please raise your card. Don't sit through the entire voir dire and then at the end say, I didn't hear anything. Now, we're gonna practice with your cards. Everyone raise your card. And don't lower your card until I tell you to lower them. And please make sure your numbers are facing forward. Thank you, number 16. All right, so when I tell you to lower your card, I'm going to need you to lower your card. Do not lower your card, number 75. I can't see your number. Turn it around. Thank you. Do not lower your card until I tell you to lower your card. Jurors 1 through 21, lower your card. Anyone else with your card still held up, this is what I need you to do for me. If somebody's asking you a question, if you're answering a question, if you can stand, I will need you to stand when you answer that. That's so everyone can hear. Is everyone able to do that for me?
Yes.
If you all do that, you will be the first jurors who've ever been able to do that for me. So I have faith in you. So you can lower your cards. Now, I want to talk to you about this case just briefly. One, the charge in this case, count 1 is murder, count 2 is deadly conduct. And I'm going to come back to you and talk to you about ranges of punishment. What I can tell you is when I speak to you, one, I'm not speaking about the specific facts in this case or what people think the facts are in this case, because number one, I don't know the facts in this case. Number two, the state and the defense are not allowed to tell you what they think the facts are in the case. They're only able to speak to you in hypotheticals. So when they're speaking to you, don't be like Mrs. Kravitz from Bewitched and saying, this is what this is about. No, just listen to what they're telling you and know that they are only speaking in hypotheticals. Does everyone understand?
Yes.
Now, I want to talk to you about indictments. What are indictments? What do they mean? An indictment is just a piece of paper. And the indictment is designed to tell anyone who's accused of a felony offense what they're being accused of. It's a sheet of paper. That sheet of paper is for the person who's accused. It's not necessarily for jurors. So what am I trying to say to you? One, just because somebody's indicted for a felony, you can't hold that against them and say, oh, you've been indicted, so that's a strike against you. You are not allowed to consider that someone has been indicted. You are not allowed to hold it against them. You're not allowed to take that as evidence of anything. Does everyone understand?
Yes.
Let me give you an example. Raise your card. We're going to practice a lot raising our card. Raise your card if you've ever had a traffic ticket. All right. So the people who didn't raise your cards, I'm so sorry because you have to drive for everybody else. But this trend continues. There's some horrible drivers here in San Antonio. All right. You can lower your card. So let's say you get a traffic ticket. An officer pulls you over. That officer says, you ran a red light. Well, when they give you that ticket, they will put on there what they're accusing you of. And they'll tell you where you need to go if you want to have a trial. Usually it's the municipal court on Frio. And on that ticket, it'll tell you, you don't have to come in. If you don't want to, you can just pay the fine, right? Well, when you accept that ticket from that officer, you're not saying, yes, officer, you're correct. I ran the red light. You are accepting that ticket because that's to give you notice. So when you go to municipal court and you're like, you know what? I'm going to trial on that because I know for a fact I didn't run a red light. So you get to municipal court, you're ready, you're doing jury selection, and you're like, I got them because I ran a stop sign, not a red light. Then lo and behold, you're in the middle of trial, witnesses are being called, and the officer's like, oh yeah, they ran a stop sign. And you're like, wait a minute, I'm supposed to be here just for running a red light, not a stop sign. I'm not prepared for this. So as you can see, an indictment is just putting somebody on notice. Does everyone understand?
Yes.
And the law says you cannot hold it against them or consider it as anything. Does everyone understand?
Yes.
Is there anyone here, raise your card, who's going to hold it against the accused just because he is here under indictment? All right, that's number one.
Tonight, inside Judge Stephanie Boyd's courtroom, two cases came to a close. In the first, the state of Texas versus Maria Anuanette Neely, the defendant pleaded no contest to a manslaughter charge and true to a repeat offender enhancement. As part of a plea bargain, she was sentenced to 8 years in prison, to run concurrently with a pending federal case. Judge Boyd followed the sentencing with a pointed warning about wasting her life in prison. In the second case, the state of Texas versus Lorenda Tanguma, the state moved forward on a lesser charge of assault causing bodily injury, a Class A misdemeanor. Tanguma pleaded no contest and received 6 months of deferred adjudication, with conditions including anger management, no contact with the complainant, and random drug testing. The case was then transferred to Brewster County. The day's most striking moment came in the Neely case, where the judge delivered what can only be called a reality check.
All right, now the next thing I want to talk to you is certain rights people who are accused of an offense has. One of the rights is the right to remain silent. If you've ever seen Paper Chase, Mannix, Beretta, The Practice, thank you, you know what I'm talking about. Then you know that everybody has a right to remain silent. What does that really mean? That means you don't have to testify if you don't want to in a criminal case. So that means that the state can't say, oh, my next witness, I'm going to call the person who's accused. They're not allowed to do that. When you are going to trial, a person who's accused of an offense has certain decisions they can make. One is whether or not they will testify, whether or not they're going to jury trial. Those are some of the things that they're allowed to make choices about. So our Constitution says you don't have to testify. You can remain silent. Now, I always ask jurors, will you hold it against somebody if they choose not to testify? And I always chuckle because some jurors will say, well, if that were me, I would get up and tell my story. And I laugh inside because I'm like, that's not you. And let me give you a hypothetical to that. Let's say you've been having chest pains and you go see a specialist and the doctor says you need heart surgery and you need to have heart surgery today. And you're like, I know you're the expert and all, but I'm going to get a second opinion. So you go to the second specialist. The second specialist, like, yeah, you need heart surgery and you should have done it yesterday. And then you're like, yeah, I know you're an expert, but I'm going to go to the third person. You go to the third person and you see that doctor, and that doctor's like, I don't even know how you're still living. We need to get you on the table right now and do surgery right away. So you're like, you know what? I'm going to go along with what this expert is saying. I'm going to let them do surgery. So when they're getting ready to do surgery, you tell the expert, you know, this is the scalpel I think would be best used in my case. And this is how I want the stiffness to be. You wouldn't do that. Why? Because that's why you went to an expert. I've been a defense attorney. I've been a prosecutor. And let me tell you, usually people who are accused of offenses, they have a discussion with their attorney and they together make a decision on, would it be best for you to testify or not? Sometimes I would have clients as a defense attorney. I would sit in the office, talk to them, and I would say, I am doing, my best for you. I'm representing you and I'm for you. And you're sweating in the office talking to me. You would not be a good witness. Then you have some people who maybe have speech impediments. And they're like, people are going to look at me different, maybe hold it against me, and I can't get my words out. Then you have some people where, as an attorney, I would tell some clients, the state can prove their case. There's no need for you to say anything. You don't need to testify. So our law says if someone decides they are not testifying, you can't hold it against them. You can't consider it. You can't be in the back room deliberating and say, well, that's a strike against them because they didn't testify. Or let's talk about the reason why they wouldn't testify. You're not allowed to do that at all. Does everyone understand? Is there anyone here, raise your card if you're going to hold it against Mr. Vasquez if he decides not to testify? All right. Now, the next thing I want to talk to you is presumption of innocence. Everyone who is charged with an offense is presumed to be innocent. What does that really mean? That means that the state has to prove their case. That means that the defense does not have to do anything because their client is presumed to be innocent. When we're in law school, and every person who is an attorney, they had that one professor, and that professor would tell them, you can play crossword puzzles at your table. You can play video games at your table. You cannot listen. The reason why they were telling that to us, because they wanted us to know that, one, as a defense attorney, you don't have to put on any evidence. As a defense attorney, you don't have to question anybody. As a defense attorney, you and your client can sit and do video games and crossword puzzles. Why? Because the defendant is presumed to be innocent, and the defense never has the burden to prove anything. Does everyone understand? The burden rests totally with the state. So they have a burden. What is their burden? Their burden is called proof beyond a reasonable doubt. When I was in law school, you had to know that definition. You had to know it forwards and backwards. I knew it forwards and backwards. When I had my first jury trial, I knew where to put the comma. I knew where to put the exclamation point. I knew where to pause for dramatic effect. And after that trial, guess what? They took away the definition. There is no longer a definition for proof beyond a reasonable doubt. So when I was trying cases, I said, well, how am I going to explain this to the jury? Because I don't want them to find my client or use a burden that's less than proof beyond a reasonable doubt. And then when I was a state's attorney, I said, well, I don't want them putting our burden beyond what it's supposed to be. So how can I explain this to them? So I would explain it to jurors by telling them what it is not. Next door, and my sense of direction, I always say next door, but they tell me it's this way. The civil courthouse with the green rooftop, the historic courthouse, they handle civil cases. Fender benders, somebody suing somebody for money. Those are the type of cases they do over there. So one of their burdens is called preponderance of the evidence. Preponderance of the evidence is more likely than not something happened. If you're on a criminal case, I don't care if it's misdemeanor court or felony court, if you are deliberating and somebody on the panel starts saying, I believe more likely than not this happened, you need to tell me, excuse me, let me let you know, we're in the criminal courthouse, we're not on the civil, you're at the wrong burden of proof. So proof beyond a reasonable doubt is higher than that. Then their highest burden is what's called clear and convincing evidence. Clear and convincing evidence is evidence that is presented that is used to terminate somebody's parental rights. They're saying you're a danger to your child. Legally, we're not going to let you be a parent anymore. That is their highest burden. But the highest burden we have in the land is proof beyond a reasonable doubt. Does everyone understand? Now, I want to talk to you about fairness. And what does fairness mean? Because people always say, can you be fair? Sometimes you have jurors, they're like, man, I was hoping I was going to get a fender bender case. Here I am on the criminal side. This is what fairness is. Let's say you get up, you get a card in the mail saying you have jury duty, and you're excited because you want to do your civic duty. So because you want to make sure you're on time, you do a test run the day before, you map out your routes, you see where there's construction, and then you say, let me see where I'm going to park. You know where you're going to park, so you know how to avoid the one-ways, you know where they are. So you get the forecast, they tell you it's going to be heavy rain. And you said, you know what, I'm going to get up extra early because I know it's going to slow things down a little bit. So you're drinking your coffee, you get up extra early, you have your umbrella, you have your lunch, you come downstairs, and your car is on cinder blocks. Somebody has taken your tires, they just destroyed your vehicle. And when you come up to a courtroom, you learn that you're going to be sitting on a burglary of a vehicle case. Usually people will ask you, this really is not the case for you. You really can't be fair in this situation. This is what fairness means in that situation. What fairness means is if all of that happened to you and you're called up for a burglary of a vehicle, if you're sitting on a jury, would you base your decision on whether somebody's guilty or not guilty, if you can come to a decision based upon the facts that are presented to you? Or are you going to say, you know what, my car was burglarized. I don't care if this person did it or not. That's a strike against them. That is basically what fairness is. Because guess what? Raise your card if you were born yesterday and slept all last night. So that's nobody. So you know what that means? That means that nobody's had a perfect life. Everybody at some point in their life has had something bad to happen to them or a family member. Does everyone understand? So that's what fairness means. So is there anyone here, if you're selected on this jury, will not be able to sit and listen to the evidence that's presented? And if you can come to a decision, base your decision upon the evidence that's presented. Is there anyone here who can't do that? All right, so that's 1, 6, and 40.
Lift off 3, Judge.
Oh, I'm sorry,
11.
number 3 and 11. Thank you. All right, now the next thing I want to talk to you about is ranges of punishment. I told you count 1 is murder. The range of punishment for murder in Texas is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And all of the felony charges, majority of them, it's a $10,000 fine. Now, where that money goes, nobody knows. It's supposed to go in the coffers of the state of Texas courts, but so we're not even going to focus 100% on the $10,000 fine because nobody knows where it goes. Now, let's talk about the range of punishment for murder. The range.
2 cases. 1 courtroom. Judge Stephanie Boyd. Maria Anuanette Neely pleads no contest to manslaughter, true to a repeat offender charge, and gets 8 years, running with her federal case. Then comes the warning, blunt and direct. Don't waste your life in prison. Next, Lorenda Tanguma pleads no contest to a lesser charge, assault causing bodily injury. She gets 6 months deferred adjudication, anger management, no contact, random drug tests. Case moves to Brewster County. But it's Neely's moment that stays with you. A judge's reality check on a life about to change forever.
The punishment is 5 to 99 years or life. What does that mean? That means if someone were to be found guilty of murder, you can decide to sentence them 5 years, 6 years, all the way up to 99 years or life. Does everyone understand the range of punishment? Now, so the question is, have you internalized the range of punishment? Has everyone done that? Internalized. When I say internalized, you've internalized that the law says that the range of punishment for murder is 5 to 99 years or life. And that can go from 5 years all the way through all of the way the numbers up to 99. Does everyone understand?
Yes.
Now, so the question is whether or not you can consider the full range of punishment. And usually sometimes jurors get confused. They're like, well, I don't know if I can give 5 years for murder. That's not the appropriate question. The appropriate question is whether or not you can consider the full range of punishment. That means internalizing, this is what the range of punishment is. So you can't sentence somebody to 2 years for murder because that's not within the range of punishment. Does everyone understand? So let me give you some hypotheticals. Let's say you have 2 couples. They've been friends throughout high school, all through college years. They end up getting married. So you have one couple, they married to their sweetheart. The other couple, they're married to their sweetheart and they're best of friends. And the women end up getting pregnant at the same time. One has a girl, one has a boy, and they start planning. They're like, wouldn't it be great if our children ended up getting married? So they're constantly throwing them together. They're in the same preschool. They go to the same elementary school. And lo and behold, the children grow up and they end up getting married. And they have their children and they age together. Their parents ultimately pass, so it's just them. Then one of them, in their later years, gets very ill. They go see an expert. Expert tells them, there's nothing we can do. This person is going to die, and it's going to be extremely painful until they die. But you know what? They're like, we're going to another expert. They keep going to experts. Experts tell them the same thing. So one of them ends up in the hospital, and they tell their spouse, I love you. And they're like, honey, I love you too. And the spouse says, look, I haven't been taking the pills that they've given me, and I'm in so much pain. Can you help me end it all? Because I just can't take the pain anymore. And so that spouse, you know, in tears, but the spouse like, yeah, I'll do this for you. And they help them. And that person dies. That's murder. Now that's a case where you may say to yourself, yeah, I could consider giving 5 years for that. Now, let's say you have the second scenario. You have somebody who's been in school, used to kick the cat on the way home, throw paper in the street, sees an old lady walking across the street when they're a teenager, pushes her down, steals her purse, and is constantly doing things like that. And everybody says, you know, that person's going to end up killing somebody. And ultimately, that person ends up killing somebody. And let's say you find them guilty of murder. Then for that person, you may consider the higher range. Does everyone understand? But the key point to considering ranges of punishment is if you were to find someone guilty of murder, would you be able, if you can come to a decision on punishment, would you be able to base your decision upon the evidence that's presented to you? Does everyone understand? Is there anyone who would not be able to do that? All right. And the next thing is deadly conduct, and that's count 2. And the range of punishment for that is anywhere from 2 to 10 years in the prison. So again, 2, 3, 4, all the way up to 10, or potentially probation. So again, internalizing that range of punishment, and I can give many examples of that as well. Whatever evidence that's presented to you, if you were to find someone guilty of deadly conduct, if you can come to a decision on punishment, would you be able to base your decision upon the evidence that's presented to you? Is there anyone who would not be able to do that? And what I'm going to tell you is that neither party, again, can tell you what they think the facts are in this case. So they can't tell you what the facts are and say, you know what, let me get your opinion now. What would you give? And these are the facts I'm saying they are. What's the punishment you would give? And I think you can see how that would be unfair, right? Because we want jurors who know nothing about the case and just basing your decision upon what you hear. Now, the next thing I want to talk to you about is certain concepts. How many of you have ever heard the words co-defendants or law parties? Raise your card if you've ever heard of that term before. All right, so I see many of you have. You can lower your card. So let me explain to you the law about co-defendants or parties. So you cannot convict somebody based upon the testimony of a co-defendant unless there's corroboration. So, and that corroboration has to be other evidence than the co-defendant saying this is what happened that tends to connect the defendant with the offense committed. So hypothetically, let's say you have a co-defendant comes in and let's just say it's a burglary of a habitation, right? And so you have 2 people who are charged with burglary of a habitation. One person is on trial for burglary of the habitation. Maybe the other one is going to trial later, or maybe the other one has entered a plea. Is everyone following my scenario so far? All right, so let's say the co-defendant who is not on trial comes in to testify. And when the co-defendant comes in to testify, the co-defendant's like, yeah, I committed that burglary of a habitation with the defendant. He and I went into the house and we stole everything. We kicked in the front door. And that's his entire testimony. And let's say that that person testifies, and that's the only evidence the state brings you, that person testimony, nothing else. The law says that you will not be able to convict because all you have is that co-defendant's testimony. So in order for a conviction to occur when you have co-defendants and there's a co-defendant that's coming to testify, you have to have the co-defendant's testimony and you have to have other evidence that tends to connect the defendant to the offense committed. And just because a co-defendant comes in and says an offense was committed and there's nothing else, that is not enough. Does everyone understand? Number 56. All right, so let me go into greater detail. All right. So let's say you have co-defendants and we're going to call John Doe and Jane Doe. All right. And let's say that John Doe is on trial for burglary of a habitation. Jane Doe comes to testify. And Jane Doe is coming to testify.
Some moments in a courtroom are about the law. Others are about a life. Maria Anuanette Neely stood before Judge Stephanie Boyd, pleading no contest to manslaughter, true to a repeat offender enhancement. 8 years, running concurrently with a federal case already pending against her. But the sentence wasn't the end. The judge looked at her and spoke, not just as a legal authority, but as someone urging her not to waste what's left of her life behind bars. In a separate case, Lorenda Tanguma faced a lesser charge, assault causing bodily injury. She pleaded no contest and was given a second chance, 6 months of deferred adjudication, with conditions meant to guide her forward: anger management, no contact, drug testing. Her case moved on to Brewster County. But it's Neely's story that stays with us, a stark reminder of consequence and a judge's attempt at a reality check.
To say, yes, I was there on that night. John Doe and I kicked in the front door of this person's home. John Doe and I went in and we stole their watches. We stole their televisions. Okay? So that is a burglary of a habitation. The only evidence you have is Jane Doe coming in and saying that's what happened. That's it. According to Texas law, that is not enough to find somebody guilty. What you would need is you would need their testimony plus other evidence that corroborates what that witness is stating. Do you understand? 56, you understand it now? Okay. Anyone else needs any more clarification on that? And then, as I said before, that corroboration, it has to be more than just showing that an offense was committed. All right? So you need, if you're going to bring in a co-defendant to testify, you need the co-defendant's testimony plus other evidence to corroborate. Does everyone understand? All right. Now, the next thing I want to talk to you about is languages. I love languages. I think languages are beautiful. I'm originally from Louisiana. You can tell when I have to say words like all and soul. My friend told me when we were in school, she's like, Stephanie, come take Spanish with me. I said, absolutely not. I don't need Spanish. We're in Louisiana. I'm going to learn French. And then by the time I'm 21, I will be retired, enjoying my life in Paris. And here I am, 22, and that has not happened. I always tell everyone, if my Spanish is not where it should be, you need to blame the deputies. They're supposed to be teaching me. I'm a great student. I need to start looking towards my teachers. So when I was in undergrad, grad school, and then law school, many people who are from the Middle East and different places, they speak so many languages. Continent of Africa, everybody speaks no less than 6 languages. I was so jealous, but they would try to teach me. So I can probably say hurry up in every language. That's the only thing I was able to learn. Navajo, extremely hard. I see why they had them as the wind talkers, because Navajo, difficult language. So I need you all to raise your card if English is not your primary language and you have not been able to understand anything that I've been saying. All right. So in this case, we are using an interpreter. This is what I can tell you about an interpreter. Some of you may speak Spanish, so the interpreter is interpreting from English into Spanish and Spanish into English. But this is what I can tell you. If you speak that language, you're not allowed to do your own interpretation. So we depend on the professional interpreter, and her interpretation is what is being said. Does everyone understand? Yes. So you cannot say, well, lean over to your neighbor or somebody and say, you know what, they're interpreting that incorrectly. You're not allowed to do that. If she says the word Tia is uncle, then guess what? Tia is uncle, whether you think it means aunt or not. Does everyone understand? But she's not going to do that because she's excellent at her job. Now, sometimes people will use interpreters because one, English is not their first language, and maybe they don't feel comfortable. Sometimes it's because, hey, look, I'm fluent in English, but it's not my first language. And this is some serious business here. So I want to make sure that I'm understanding the terminology. And then sometimes I will tell you, you have interpreters who go to school, and the reason why they're going to school is because they have to learn the legal terminology. Does everyone understand? So in this case, Mr. Moreno Vasquez is using an interpreter. Is there anyone who's going to hold it against him because he's using an interpreter? All right. Now, the next thing I'm going to talk to you about is two stories. They're both true. I always tell jurors this: jury duty is an inconvenience. It is not a sacrifice. It's nowhere near sacrifice. Why is it an inconvenience? It's an inconvenience. Oh, I'm sorry. Before I say that, anyone has any time constraints? We're going to start with testimony in this case this afternoon. I expect this trial to be concluded by Monday, maybe sooner. Anyone who has any time constraints with regards to those parameters, raise your card. I'm gonna let it marinate, then you all can raise your card, because once I call your number, I'm not going to come back to it, okay? So that's number 2, 4, 6, 9, 10, 11. Oh, you can lower your card once I call your number. 15, 16, 22, 26, 28, 29. And if your number is not facing me, I'm going to skip over you. 30, 34, 37, 48, 49, 51, 55, 59, 60, 61, 66, 67, 69, 75, and 74. All right, 74, what's your time constraint?
Today and tomorrow.
You need to stand up.
Oh, today and tomorrow.
Yes, but what is the issue?
I take care of an elderly. My mom, she's 92. She has Alzheimer's. She lives by herself. And I watch her daily.
All right, thank you. 75?
I have job interviews on Friday.
What time? All right, thank you. Number 69?
The reason is I'm going on a trip this weekend from Thursday to Sunday.
Where to?
South Padre,
Why?
for a friend's birthday.
Isn't it gonna get rained out? All right, thank you. 67.
Because of work.
All right, thank you. 66.
I have a funeral that I'm attending on Thursday morning.
I'm sorry to hear that. What time?
Seems at 10:30.
All right, thank you. 61.
Work.
All right, thank you. 60.
Work.
Thank you. 59.
Work and childcare.
What's your childcare issue?
I have nobody to take them to.
What time do you take them?
7:30.
And when's pickup?
Order.
All right, thank you. 59, 55.
It's work.
All right, thank you. 51. 49.
Work.
48.
I'm out of town for work on Thursday.
All right, what are you doing there?
I'm a nurse and I'm in training in Houston.
I'm sorry, could you?
I'm a nurse and
Yeah.
I'm in training Thursday and Friday in Houston.
All right, thank you. 37. Number 37.
Possibly traveling to Mississippi with family over the weekend
For what purpose?
to visit family,
All right, and what day?
Friday to Sunday.
Do you really want to visit family?
You know,
Okay, I'm gonna take that as a no. All right. Number 34.
Got to a hospital. And I can't remember,
All right, what date and time
Thursday,
and what time?
I think it's around 10 o'clock.
All right, what, are you married?
Yeah.
All right, what does your wife have on the time thing?
This is her wife.
Usually the women know what time it is. Number 30,
Work and childcare.
what's the childcare issue?
She has to go to summer school, the last day of summer school, complete her finals.
What is the drop off
It's at 8.
and pick up?
Ups, I think at 12, whenever she's done with her finals.
All right, thank you. 29,
Work.
thank you. 28,
Work.
26,
Work.
22,
Work hours.
16.
Childcare and a trip over the weekend to the LP care.
All right. And when is the trip?
We're leaving Friday.
I'm sorry?
We're leaving on Friday,
Okay. What time?
right around 3.
Number 15,
Work.
11,
Work Wednesday, Thursday, my wife has surgery, and then Friday I have to watch my son, because my wife will be recovering.
all right. 10,
Work and a doctor appointment at 10 on Friday.
9,
I watch my grandsons Wednesday through Friday.
6.
It's work and taking my mom to a doctor's appointment on Friday
What time is the doctor's appointment?
at 10.
4.
Doctor at 9:40.
I'm sorry, what?
Doctor, 9:40,
What day?
Friday.
Thank you. Number 2,
Work and childcare,
when's pick up and drop off?
pickups on Fridays at 5:30 and I have them till Monday.
All right, thank you. All right, so back to my 2 true stories. Jury duty is an inconvenience. It's not a sacrifice. It's nowhere near a sacrifice. It's inconvenient because you have to drive downtown. It's inconvenient because you're sitting on hard benches, which you should contact the commissioners about that because I'm not in charge of that. It's inconvenient because you have to pay for parking. You're probably saying, why do I need to pay for parking? I'm helping you all out. Not in control of the parking. This is what I say a sacrifice is. My family grew up in a small town called Grand Cane, Louisiana. Town where everybody knew everybody. The teachers not only knew all of the students in their class, they knew all the students in school. So my grandmother's firstborn, my uncle, ends up going to high school. And they would tell my grandmother, they would say, Miss Lane, we taught him all we can teach him. And they'd move him to the next grade. Now, when his brother and sisters end up going to school, they didn't like that too much. You know why? Because the teachers told them, this is the gold standard, and this is what we're expecting of you. So my uncle ends up graduating, and there's a conflict that breaks out. You may have heard of it, called the Vietnam War. My uncle goes to my grandmother and says, because of civil rights and what's going on, there's no way for me to improve my lot in life here. And my uncle was super intelligent, knew about computers and everything before other people did. So my grandmother has to sign for her firstborn child to go off and fight in a place that she knows nothing about. My grandmother had a 6th grade education, but she was super intelligent. She babysat me while my mom was at work. She taught me how to read and write. I knew about Erica Kane and Raven. You know who I'm talking about. I knew how to answer the phone. I knew how to tell the insurance salesman we don't want any. I did say yes to the childcraft books and encyclopedias, which my mom saw the bill for that, but I still have them to this day. Now, when my grandmother sent her firstborn off to war, young people, it wasn't like it is today. My grandmother, if she were alive, would be shocked that you can take a photo and send it to somebody, they'll have it the same day. She will be shocked that you can video call someone. So my grandmother did have a phone. The phone didn't have any numbers on it. You can always tell the era people are born in by their index finger. I'm from the rotary era, trying to win prizes from the radio. When we got redial, oh my gosh, that was like, wow. So her phone didn't have any numbers. So how did she reach people? You would pick up the phone, the operator would answer, and you would tell them who you would want. That's why you would have songs like Beechwood 45789, because you want the person at Beechwood 45789. She did have a television. It had 3 stations, ABC, CBS, and NBC. The way the weather is today, you would not be able to get NBC, because to get NBC, the weather had to be perfect. That means no breeze. If you got a breeze, there was going to be static. No amount of aluminum foil on your rabbit ears is going to make NBC play any better than what it was. Then the way you young people like, oh my gosh, there's everything on TV, but there's nothing to watch. I've seen it before. Guess what? Back in the day, programming would end. You would know it had ended because they would play the national anthem, and either your screen would just have static on it, or either they'll leave the American flag blowing in the wind. So my grandmother would write to my uncle. She had his name, she had his ID number, and a lot of the men in my family have joined the military. So I'm sure it was the same back then, the way it is now. Wherever your boots hit on the ground when you leave your home, you need to write a letter letting people know, your loved one, whoever it may be, write them a letter and let them know that you have arrived. So my grandmother had to sit, watch the news, see what's going on with her baby. And I used to always end that story right there. And then the deputies are like, Judge, what happened to your uncle? Well, my grandmother realized you do not want to get that knock on your door, because if you get that knock on your door and people are in uniform, not good news. So my grandmother got the knock on the door from people in uniform that her son had been severely wounded in the war. He did survive. He made it back. He continued doing his time in the military. He would go to different places. And because I was the youngest niece at the time, I would always get the presents. He would come in, hug me. That is why to this day, whenever I smell Old Spice, it makes me think of him, because Old Spice back in the day was the rite of passage for men. You knew you had reached manhood when you were able to use Old Spice. So he's since passed, and some of my aunts have since passed, and my grandmother. But I tell that story to you to tell you that's what a sacrifice is. Sending your firstborn off somewhere that you don't know anything about, you're not getting updates on, and you're sending them into danger. Your country only asks 2 things of you. They ask for you to pay your taxes and show up for jury duty once in a blue moon. That's all they ask of you. And I see people, Veterans Day, 4th of July, Memorial Day, people raising their flags, support our troops. But then when your country asks you, because they don't even have the draft anymore, when your country asks you, hey, can you give us, 3 days for jury duty to listen so that we can uphold the Constitution and somebody can have a jury trial? Usually people try to get out of jury duty. Usually people say, oh, I have other things that I have to do. So this is the inconvenience your country is asking of you. They're not asking a sacrifice. Each side is going to have 40 minutes to speak to you. I had a friend in law school. She ended up having jury duty. She practiced civil law. And she said, Stephanie, I'm free. Let's have lunch. I have jury duty. I'm like, great. So we're having lunch. I asked her, how's jury duty going? She's like, oh, it's going great. I'm like, that's really odd to say that it's going great. I said, why do you say that? She said, because it's like law school. I'm on the back row. I'm keeping my head down. Nobody has called on me. And I said, well, I am very happy and ecstatic. She said, why? I said, because we're going to be able to have lunch all week. So other than raising your hand saying, please, I want to be in this jury, the quickest way to be on this jury is not to say anything. Because both sides, they don't have time, regardless of what you've seen in Runaway Jury and all of these other movies, they don't have time to go out to your house, sit with you, talk with you. They don't have somebody who's going to be going in your trash can to see if you would be a good juror or not. So, anyone need a break before I turn it over to the stage? All right, so everyone, look to your left.
The following proceedings took place in the courtroom of Judge Stephanie Boyd. In the matter of the state of Texas versus Maria Anuanette Neely, the defendant entered a plea of no contest to a charge of manslaughter and pleaded true to a repeat offender enhancement. Pursuant to a plea bargain agreement, the court sentenced the defendant to 8 years of incarceration, to run concurrently with a pending federal case. Following sentencing, the court addressed the defendant directly regarding the consequences of her actions. In the matter of the state of Texas versus Lorenda Tanguma, the state proceeded on a lesser included offense of assault causing bodily injury, a Class A misdemeanor. The defendant entered a plea of no contest and was granted 6 months of deferred adjudication, subject to conditions including anger management counseling, no contact with the complainant, and random drug testing. The matter was subsequently transferred to Brewster County.